Good evening to all. I am Manu Sebastian, Managing Editor of LiveLaw. I welcome you all to the second lecture of LiveLaw's 10th anniversary lecture series. We are organizing this lecture series to mark and celebrate LiveLaw's 1 decade in revolutionary legal reporting. To deliver today's lecture, we have a very distinguished and erudite personality with us. We are very honored and privileged to have former Supreme Court Judge, Justice Deepak Gupta, to deliver today's lecture. On behalf of Team LiveLaw, I welcome you, sir.
Thank you, Manu. It's a privilege to be here on LiveLaw. First of all, I must congratulate you for completing 10 years of very successful reporting and doing great service to the legal fraternity. I wish we had had something like LiveLaw when I was on the other side practicing at the bar. It would have made life much easier.
Thank you so much, sir, for your kind words. So today's lecture will be on the topic developments on fundamental rights jurisprudence in the last 1 decade. So after Justice Deepak Gupta's lecture, we'll be having a short interactive session. So the interested viewers may comment in the YouTube comment box their queries. So we'll be having a short talk, a short discussion with Justice Gupta after his talk. So I welcome you all. Enjoy the lecture. Thank you.
A very good evening to all of you. Today's lecture is basically on the development of law, the constitution law, over the last 10 years, especially in the field of dealing with Part 3 of the Constitution in respect of the fundamental rights. The modality which I have followed is that I've gone through the judgments. In my view, I've not followed the system. The 9 judges judgment should be cited, is the most important, or the 7 judges judgment is the second important. For me, when we think of the fundamental rights of the citizens, what is most important is to decide what is the effect which each of these judgments has on the citizens of the country. And I think there's some disturbance. Some people have their mics on and videos on. I'm so sorry. So it is very important to see what is the effect which each of these judgments have had on individuals, on citizens as a whole. I've taken these judgments chronologically and not in an importance in any other way. The first judgment which comes to mind is Lilu's judgment, Lilu versus State of Haryana, wherein the court dealt with the two-finger test, a reprehensible test, an archaic test developed on very patriarchal societal norms which involved a medical practitioner inserting 2 fingers into a woman's vagina to ascertain the laxity of the vaginal muscles and to find out whether she was habituated to sexual intercourse. Now, this practice which was going on for more than a century, had no medical backing. And the Supreme Court, in a judgment authored by Dr. Justice B.S. Chauhan, said, the test has no scientific backing as proved by the doctors and thrives on the archaic concept of a hymen determining whether a woman is a virgin or not. Another very important observation in this judgment, and I can do no better than quote from the judgment itself, was that medical procedures should not be carried out in a manner that constitutes cruel, inhuman, or degrading treatment, and health should be a paramount consideration while dealing with gender-based violence. So the dignity of a woman, the dignity of a human being, was being adversely affected by conducting this test, and therefore this test was set aside. But like many other decisions of the Apex Court, it was not followed for many years. And again, in Shailender's case, Justice Chief Justice Chandrachud and Justice Hema Kohli had to reiterate this view and hold that this test, this two-finger test, has no place in a civilized society. The next important judgment which comes to mind is the judgment in PUCL's case relating to the none of the above category or the nota judgment. The issue before the apex court was whether their citizen had a right to say, I do not want to vote for any of the candidates who have stood for election. And here again, the court said that though the right to vote may be a statutory right, each citizen had a constitutional right to decide who to vote for, and also to decide that did not want to vote for any of the persons who had taken the plunge and come in for election. This is an important judgment in my view because in a democracy like India, it really emphasizes what is the role of a voter. It is the voter, it is the citizen who should decide how the democracy should run. It is not anybody else, but it is the voter who will decide that. Therefore, according to me, this is another important judgment. Then came the very important judgment by Justice K.S. Radhakrishnan and Justice Sikri, wherein in the Nalsa case, wherein they held that the transgenders could identify themselves as the third gender. So people who had been marginalized in society as third genders, who were not treated as male or female, and in fact were not even treated like human beings, were given the dignity of having to describe themselves as a third gender and to identify themselves differently from both male or female. This is a remarkable development in the law. And the court really emphasized in the last couple of months, or maybe the last 1 year, there's been a raging debate on this, both inside and outside court, as to what is meant by gender. But in that judgment, it was said that gender identity did not refer to biological characteristics, but rather referred to it as an innate perception of one's gender. So gender does not have to necessarily be physical only. It can also be the hidden traits within the body, within the mind, which will determine the gender of a person. And therefore, it was further held that no third gender person could be subjected to any medical examination or biological test which would invade its right to privacy. This is important because this came before Puttaswamy's judgment. This was not after. And the court held that the right to dignity, which is guaranteed to every citizen of this country under Article 21 of the Constitution, includes the right to self-expression even in matters of one's sexual orientation. So this is another remarkable judgment which led the way and which laid the basis for other judgments which followed and which I shall discuss later. As far as I am concerned, one of the most important judgments of the last decade has been the judgment authored by Justice Nariman sitting with Justice Chalmeshwar in Shreya Singh's case. It has widened the scope of freedom of speech. It has restricted the scope of the rights or scope of the limitations which can be laid on this right of speech. The background of the case is that after the death of a political leader from Maharashtra, buns, etc., were taking place in Bombay, and two young girls circulated some posts on Facebook, sort of condemning the buns. Now, this was thought to be offensive and capable of creating some problems for the police, and therefore these girls were arrested. They were released, and no case was filed against them. But a law student, Shreya Singhal, filed the petition, which was heard by the bench of Justice Chanmeshwar and Justice Nariman. And Justice Nariman, dealing with Section 66A of the Information Technology Act, held that the right to freedom of expression guaranteed under Section 19A of the Constitution of India is an important right. And though Article 19(2) permits the government to impose a reasonable restriction in the interest of sovereignty and integrity of India, the security of the state, friendly relations, etc., this must be shown to be possible and probable. One important aspect of this judgment is that Justice Nariman divided freedom of expression into three portions: discussion, advocacy, and incitement. He said discussion and advocacy of any point of view, though it may be unpalatable or obnoxious, could not be stopped. It is only if there was an incitement that the state could step in and stop further dissemination of such information. So the right to free speech could not be curtailed at the stage both of discussion or of advocacy. It is only when incitement takes place, incitement to violence or public disorder, etc., that the state can step in. The other aspect of this case was that the court found that the definition was too wide. So something which was annoying or inconvenient would fall within the ambit of the section. And therefore the court held that this section was capable of having, I quote, a chilling effect, unquote, on the right to freedom of speech and expression, and therefore could not be sustained and was accordingly held to be unconstitutional. This is one of the most remarkable judgments as far as freedom of speech and expression is concerned in the recent years. Another extremely important judgment is the judgment in the NJAC case. You're all well aware that in the first judge's case, the Supreme Court had held that the executive would have primacy in the appointment of judges. Later, in the second judge's case, that is the one by the Supreme Court Advocates on Record Association, the concept of collegium was evolved. And then, with the 9 judges case, this was widened, and the Chief Justice had to take into consideration the opinion of the 4 senior judges, and a collegium was established as such. With a view to upset these judgments, which the powers that be felt were against the spirit of the Constitution, they introduced the NJAC Act, wherein a committee of various people, including lay people, people from the government and from the judiciary, were to sit together to decide who should be appointed as judges of the High Court in this. The court, by a 4-1 majority, Justice Chalmeshwar dissenting, held that the Act violates the principle of separation of powers and, more importantly, affects the independence of the judiciary. And it again upheld the system of appointment by collegium, though it laid down certain safeguards in the manner in which the collegium should function. Whether the collegium is functioning as per the expectations of the bench is something which would require a much longer discussion, and I won't get into that. But for me, the importance of this judgment is that this judgment holds that there is separation of powers and that the independence of judiciary is paramount in our constitutional scheme of things. In fact, there can be no real democracy if the judiciary is not independent. The NJC Act gave supremacy and the veto power finally to the government. If you counted everybody, the last word did not lie with the judiciary. Maybe if the last word had lain with the judiciary, the court might have had a different view, but that we will learn maybe at some other stage when, if and when the government comes out with another version of the NJC. The next important judgment of the Apex Court or Development of Law is the judgment dated 12th August 2016, delivered by Justice Sikri in Anita Thakur versus Government of J&K. This was a case where the migrants from the state of J&K were protesting. They were stopped at a place called Katra and they were not permitted to hold a protest. Justice Sikri held that the right to protest, the right to dissent is inherent in Part 3 of the Constitution. Relying upon Article 19 of the Constitution, he held that the right to expression, to raise slogans, the right to assemble, the right to move, all are rights guaranteed within the ambit of the Constitution. And therefore, these could not be taken away except in accordance with the constitutional provisions themselves. But importantly, he also held that though every citizen had this right to protest, this right could not be exercised in such a manner that it affected the rights of another citizen who did not want to take part in the protest and who wanted to go around his normal life like an ordinary citizen. This view was again reiterated in Amit Sani's case by a judgment delivered by Justice Paul during the Shaheen Bagh incidents. And both these judgments hold that though the right to protest is there and you can protest even on a public space, but you cannot protest in such a manner that later the public space cannot be used by the ordinary citizen for whom that public space is earmarked. As Zakaria Shafi said, your right to swing your arm ends just where the other man's nose begins. So you can swing your arm as long as it does not affect the right of another man. And therefore, these two judgments are also important. Then came the judgment in Shaira Banu's case, or commonly known as the triple talaq case. This was a 5-judge bench, and Justice Keher and Justice Nazir gave the dissenting view, authored by Justice Keher. Justice Nariman gave another view, which was his and Justice Uday Lalit's view. And Justice Kurian Joseph took a view which was somewhat in between. But the majority did find that the practice of triple talaq had no place in Muslim law, though Justice Nariman went on to hold that it also violated Article 14 of the Constitution, 14 and 21 of the Constitution, and therefore could not stand scrutiny. Justice Kurian did not go as far. He said that it is not proved that triple talaq is an accepted part and parcel of Islamic law, and therefore it could be challenged, but not on any other ground. So this judgment is also very important in the context that what is the role of a court in deciding ecclesiastical matters? How far should the court go in deciding matters of religion? In most countries, courts don't even enter into this domain. However, in India, we have been entering into this domain. And as I will deal further, there have been other judgments in this field. But a question which does arise is whether, when there is a conflict between fundamental rights and religious practices, or established principles of religion, can the courts intervene? There is a split verdict in this case, but later in Sabrimala case, a view was taken that the court could not interfere in such matters. Probably the most important judgment of the last decade has been the 9-judge judgment in Puttaswamy case, commonly known as the right to privacy case. There was a divergence of opinion prior to this as to whether the right of privacy is one of the fundamental rights guaranteed to each and every citizen of this country. In fact, an 8-judge bench in MP Sharma had held that the right to privacy is not protected by the Constitution. This was specifically overruled in Puttaswamy. Even in Khadak's case in 1962, the Apex Court had held that the right to privacy was not one of the rights which could be read into the Constitution. However, there were other judgments which had taken the contrary view and which had indicated that the right to privacy was also a right which would form part of one of the human rights or fundamental rights guaranteed under Part 3 of the Constitution. By a way of digression, I may add that sitting as a judge of the Himachal High Court, I myself had taken a view that the right to privacy is part of Article 21 and could be read into Article 21 of the Constitution. The judgment of this court There are different, there are, I think, 5 or 6 opinions rendered. The main being by Dr. D.Y. Chandrachud, the present Chief Justice of India, who spoke for himself and 3 other judges. And there were, I think, 4 or 5 other opinions. The various issues arose, whether the right of privacy exists, which was held that it exists. It's a part of Article 21 of the Constitution. Then the question arose whether it is only available against the state or also against non-state actors. If we read the judgment fully, I think the majority would be that it applies even against non-state entities. The judgment gives various examples of what amounts to infringement of the right of privacy. But these are early days. The judgment is barely about 6 years old. And this is going to be a right which is going to evolve. Like the right to life evolved over in the 80s and 90s to include environment, dignity, everything. My personal view is that the right to privacy is also an evolving concept, which over the next couple of decades will widen, and the scope of the right to privacy will be widened so much that it will take into its ambit and into its fold many factors which at present we may not even consider to be part of the right to privacy. What restrictions can be placed on the right of privacy? It will be those restrictions which fall within the meaning of Article 92 and Article 20. Those restrictions alone can be placed on the right to privacy. To give an example, if for the security of the state, somebody's phone has to be tapped, it can be tapped, as long as there are certain guidelines as to which is authority, what is the reasoning behind the tapping, who is given the power to tap. It can't be done just because a constable somewhere feels that I want to tap somebody's phone, so I'll tap it. There have to be certain well laid down norms on the basis of which such invasion of the right of privacy can be done. The interpretation by the court, especially because there were a large number of judgments, has paved the way, as I said before, to various claims being claimed under the right to privacy. And as I discuss further, the right of privacy is being now expanded and in such a manner that even the dignity of a woman read with privacy is giving her various rights. We shall discuss those judgments as we go further on. I hate to sound narcissist, but I couldn't but include one judgment where I was also party. I actually didn't want to include any such judgment, but I do think it's an important judgment. And that is the judgment rendered by Justice Lokur and myself, 2 concurring judgments in Independent Thought versus Univinte. Under Section 376 of the IPC, while defining rape, there was an exception, and a man would not be guilty of rape if sexual intercourse was committed with his wife, who was less than 18, but more than 50. Now, under IPC, as unamended prior to 2013, the age of consent was 16. It was, by amendment, increased to 18. Even under the POCSO Act, the right, anybody having consensual sex with a girl aged less than 18 would be guilty of committing an offense. And therefore, the question before the bench was whether this exception was unconstitutional. Today, after my retirement, I can share that one thing which worried me, which niggled me a lot while deciding this case was that does the court have the right to create an offense? And in the judgment, we've answered it, and especially in my judgment, in my opinion, I've answered it by saying that the offense was there in the main section. What we have done is set aside the exception. So we've not created an offense. So in that sense, again, an important landmark judgment of how interpretation by the court can, in a sense, make something an offense. Then comes another judgment, a very important judgment, Common Cause versus Union of India. As I mentioned earlier, there are many judgments which flew out of the right to privacy. And this is another one of those in the long range of judgments. Here, Article 21 of the Constitution of India, where the right to life has been read to mean the right to live with dignity, was also held to include the right to die with dignity. Earlier, one bench of the Supreme Court had held that the right to die with dignity is not part of Article 21 of the Constitution. Later in Aruna Shanbag's case, the court did permit passive euthanasia, but under very, very strict conditions. This was the first time in this common cause case that the court laid down a system where any citizen could, in a sense, create a living will, giving directions to medical personnel that if his or her medical condition reaches such a state that he or she has no scope for recovery, and it is painful and the patient does not want to live any longer, then the doctor could pull away the life support systems and let the patient die in peace. So this is a remarkable judgment to show how the courts, even in the absence of the legislature taking action and legislating, can move forward, can move with the times, and accept a new concept of euthanasia, or a developing concept of euthanasia, and affirmed the right to die with dignity as being one of the rights. It relied upon Puttaswamy's judgment to hold that the right to privacy has an innate connection with autonomy and liberty. And that would be the autonomy of the patient and the liberty of the patient to decide whether he or she wants to live or die. The next judgment may not be so important in the context of Part 3 of the Constitution, but is a fallout from the Puttaswamy judgment, is the judgment in Joseph Shine, wherein the court struck down Section 497 of the IPC, which made adultery an offense. As you're all aware, adultery was an offense, one of those offenses where only the man could be convicted and the woman could not even be termed to be an abettor. Other than gender bias, one of the main reasons which again weighed with the Supreme Court was that this law violates basic human rights in as much as a woman is treated as a chattel, as property. And therefore, she cannot be even charged with an offense or charged to be an abettor. And this only perpetrated patriarchal domination. The next judgment, I'll only briefly refer to it, is the judgment in the Aadhaar case, wherein, again, a 5-judge bench dealing with Aadhaar, 4 judges, Justice Sikri authored the judgment on behalf of himself, Chief Justice Misra, Justice Khanwilkar. 3 judges held that most of the provisions of Aadhaar did not violate the UIDAI Act, did not violate the right to privacy. Justice D.Y. Chandrachud was the sole dissenter, and he struck down the entire provisions of the Aadhaar. Again, this judgment is based basically on the right to privacy. One can have a long discussion on this judgment, but at this stage, when one is discussing almost 10 years development in 45 minutes, it's not really possible to do so. But again, this is a judgment based on the concept of right of privacy. The next important judgment, which again, in my view, is one of the most important judgments of this decade, is the judgment in Navtej Singh Jauhar's case, wherein the court struck down Section 377 of the Indian Penal Code, which criminalized consensual sex between 2 persons of the same gender. We are all aware that Justice Muralidhar and Justice Katju had given the celebrated judgment in the Naz Foundation case, which as judges of the Delhi High Court, which had held that Section 377 violates Articles 14, 15, 19, and 21 of the Constitution of India. This judgment was reversed in Suresh Kumar Kaushal versus Naz Foundation in the year 2013. That is in the beginning of the decade about which we are talking. And the matter was thereafter referred. No, thereafter, certain individuals filed petitions under Article 32 of the Constitution. And these matters were referred to a 5-judge bench. And all 5 judges took the view that Section 377 is unconstitutional, cannot survive. The reasons they took the view was that it violates Article 14 since it discriminates against individuals on the basis of their sexual orientation and gender identity. It violates the right to autonomy and dignity guaranteed to every citizen under Article 21. And it penalizes private consensual acts between same-sex persons. This judgment is the forerunner of many, I'm sure, of many other cases. We already have one case pending in the Supreme Court with regard to same-sex marriages. There, from what I hear about what I've read in the papers about what has been argued, the question is not so much as to dispute whether sex marriage should be allowed or not. The consensus seems to be that it should be allowed. But the difference in opinion is whether it should be allowed by the legislature or does the court have the jurisdiction to allow it. Now that is, we will wait for the court's judgment on that. And I would not like to say anything else But again, in this judgment, the right of privacy was again invoked. Puttaswamy's judgment was again invoked. And it was held that the fact that in Kaushal's, the other bench, earlier bench had held that Section 377 affects only a minuscule proportion of the population, is no ground to hold the right to deny the right of privacy to same-sex persons. So on this is another important judgment. There are many other important aspects of this judgment, but it's not, I don't really have the time to discuss all. The next extremely important judgment is the judgment in Sabrimala's case, wherein by a 4-1 majority, the apex court held that religion by itself is intrinsically linked to the dignity of a human being. And the practice of demarring women during the period of menstruation from going to religious places of worship is abhorrent and violates Article 14 and 21 of the Constitution. Justice Chandrachud, the present Chief Justice, also said that any practice which violates constitutional morality cannot be allowed to, cannot be permitted. Again, various aspects of constitutional laws were discussed. But I would like to emphasize what Justice Chandrachud, though his was a separate one judgment, what he said was that the psychological characteristics of women, like menstruation, have no significance or bearing on the entitlements guaranteed to them under the Constitution. The menstrual status of a woman cannot be a valid constitutional basis to deny her the dignity, and that stigma had no place in constitutional order. Justice Indu Malhotra took the view that it is not for the court to decide whether the practice being followed by a religious order is valid or not. Another question which came up for consideration in this case was whether the Ayyappa sect was a separate sect or part of Hindu. That's really not part of my discussion today, so I'm not dealing with that. The next important, extremely important judgment in the context of freedom of right to speech and expression is the judgment of the apex court in Anuradha Bhasin versus Yono Vidya. We are all aware that even just before Article 370 was invoked, the Union of India had started placing restrictions on the use of internet in the state of Jammu and Kashmir. And this was challenged by Anuradha Bhasin, who is the editor of one of the largest circulating newspapers in the valley. The court decided everything in favor of the claimants. And it's a very long, elaborate judgment going into hundreds of pages as to what is the meaning of the right of freedom of speech and expression, and that it cannot be curtailed. But after having said all that and decided everything in favor of the claimant, it just remained a Pyrrhic victory for the claimants, because they were not given any substantial relief. Finally, the court said, we leave it to the state to decide in what manner and how these rights should be restored. I think the constitutional courts, once they decide that something is unconstitutional, once they decide that something is not in accordance with the Constitution, must go full hog and should not waver while guaranteeing relief to the citizens. Because once the citizen has been able to prove that his rights have been violated, that citizen must get complete justice. The next important judgment, according to me, is the judgment in X versus Principal Secretary, delivered on 29 September 22 by Justice Chandrachud. This is also an important judgment because it accepts and the woman's right to reproductive choice to be an inseparable part of her personal liberty under Article 21 of the Constitution. It was held that a woman has a sacrosanct right to her bodily integrity. And therefore, even though the Act did not provide so, the court held that the woman had a right to make reproductive choices, and this also fell in the dimension of personal liberty. And therefore, the right of the woman to procreate or to not to procreate was accepted as being part of her right. And as such, under the MTB Medical Termination of Pregnancy Act, the unmarried women were also given the right to seek termination of pregnancy. Reservations have been part of our system. We had reservations from the very beginning for the scheduled castes and the scheduled tribes. Later, reservations were introduced for backward classes, and the scope for backward classes expanded over time from time. Many times it was felt, but that why should the poorest of the poor in the so-called forward classes suffer? And thus the government stepped in, and by the 103rd Amendment to the Constitution, made a provision in the Constitution for 10% reservation for the economically weaker sections. Again, this judgment is a very long judgment. 3 judgments in majority, all separate, concurring opinions, and 1 judgment in the dissenting authored by Justice Ravinder Bhatt with Chief Justice U. Lalit agreeing with. But we must remember that in this judgment, even the minority does not say that there cannot be a reservation for the economically weaker sections amongst the so-called forward sections, classes of society. What the court said was that why are you leaving out the 10% of the poorest of the poor in the scheduled caste and scheduled tribe also? So it was that they wanted them to be considered as part, so they could have a reservation both under as scheduled caste and scheduled tribes, and also as being part of the poorest of the poor. But this judgment, in my view, is very, very important, because for the first time in our history, in our constitutional history, has economic reservation by itself been accepted to be permissible under the Constitution, and the state has been permitted to amend the Constitution. We had talked about in the NJAC case, the Apex Court had talked about the independence of the judiciary, the autonomy of the judiciary, and how judges should be appointed. A similar matter relating to the Election Commission of India came up for another bench of the Supreme Court of India in Anup Baranwal versus Union of India. And there are 2 main judgments by Justice Joseph and Justice Rastogi, which both say that there should be a separate body. And they had indicated that the body, till the state, not indicated, but they had directed that till the union comes up with an act in this regard, the body would comprise of the Prime Minister, the leader of the opposition and the Chief Justice of India. Now, the union government has brought in a bill wherein the Chief Justice of India has been excluded and has been replaced by a minister of the government. I wish I could have ended my speech, because that would have said wonders for the Supreme Court. This is all what was the good that was done in the last 10 years. But unfortunately, there have been some judgments which strike at liberty, which strike at freedom. One of the most cherished rights given to every citizen in this country is the right to live with liberty. Many, many years back, Justice Krishna Iyer said, bail, not jail, is the rule. But we seem to be moving a totally different way. In National Investigation Agency versus Zahoor Ahmed Shah Vatali, a case under the UAPA Act, challenge was laid to an extremely well-written judgment delivered by Justice Muralidhar, who retired a few days back, and in which he had read down certain provisions of the UAPA, and while granting bail, had discussed the merits of the case. The UAPA Act provides that, well, you take the police diary as the gospel truth and then decide. He took the police diary as a gospel truth, but he found various inconsistencies in the police diary and the material collected by the police, and therefore granted bail. The Supreme Court, in a judgment authored by Justice Khanwilkar, said the court had no business to enter into a discussion and dissect the evidence in the case. In my view, this judgment is a death knell to personal liberty. It virtually makes it impossible to get bail. We live in a country which is governed by a constitution. And we cannot be deprived of our liberty except in accordance with procedure established by law. Many years back, in the celebrated Menka Gandhi case, Justice Bhagwati had said that the law which lays down the restrictions must be a fair law, must be a just law. The conditions laid down in the UAPA Act can by no stretch of imagination be called just or fair. A similar judgment was given in the P.N. Chaudhary case, again authored by Justice Khanwilkar, wherein the earlier judgment of Justice Rohinton Nariman was set aside. Now, the PMLA judgment is, in my opinion, even a bigger blow than the Vatali judgment. It turns the criminal law on its head. Let's assume that I'm assuming that everything is right. That yes, whatever the police says has to be accepted, the gospel truth. But why can't the police see all the material? Why can't the court see all the material which has been collected and decide whether that itself shows a prima facie case or not? The officials of the ED have been given every police power which you can imagine under any police state, but they are held to be not police officers. A statement made to them is inadmissible, is evidence. Burden of proof is reversed and it is now for the accused to prove his innocence. And the justification given is some international covenants and on drug laws, etc., money laundering laws. Yes, we need to be very strict with these laws. We need to be, but then we need to convict people under the laws, not just send them behind jail. I ask myself the question that if burden of proof is on the side of the state, they don't have to prove anything. If what they say is the gospel truth, that is accepted. Then why should trial not finish within 2-3 months? Then why should investigation go on in these cases for 6, 8 years? And if that be so, does not the accused have a right to say that I should be granted bail because you have taken away my right to liberty? You are taking away another fundamental right of having a quick and speedy fair trial. These laws, in my opinion, offend every sensibility of a civilized society. And these laws had no place in our jurisdiction. These judgments, I hope, will be set aside. Another, I won't say a judgment, but an observation, which was not called for, was the one in the Jafri case, where Ehsan Jafri's wife had come to the court saying that the SIT report exonerating certain high officials should be set aside and fresh investigation should be ordered. The court may be right, and I feel, in fact, it was right in holding that the SIT report could not be interfered with. To that extent, the court may have been right. But how could it make an observation and virtually direct that certain people who were so behind the so-called public interest litigation should be dealt with strictly in accordance with law? A constitutional court should be very careful while making certain observations, and observations which affect the liberty of the citizen. We all know what happened in this case. Next day, Tista Sitalwad and one retired senior police official were arrested. One was already behind bars, so he didn't need to be arrested all over again. Can the court make such observations without even giving a notice to the person against whom such observations are being made? Does not this go against the very principle of a fair hearing, which we have read into even domestic inquiries by reading that into Article 14 and 20? So this, and there are a few other judgments where the court, in my view, failed to uphold, the Supreme Court especially failed to uphold the liberty of the citizen. Lastly, I would say that there was also failure of the Supreme Court in the field of fundamental rights by not deciding certain matters. Why should habeas corpus petitions be not decided for months on end? When I joined practice in the year 72, and even when I became a judge, it was the practice that habeas corpus petitions could be taken up in any time of day or night, and they would be decided in a week or 10, 15 days at the maximum. Now, many habeas corpus petitions are pending, kept pending rather. And once the detinue is released, the petitions, they are said to disposed of as having become infructuous. It reminds me of what Justice Rangarajan and Justice Agarwal did as far back as 1975 during the emergency days, when the detention order against Mr. Kuldeep Nair was withdrawn, and the counsel for the central government said that now that we've withdrawn the order, you kindly say that the petition has become infructuous. They said no. The detainee has a right to know why he was detained even for a single day and whether his detention is legal or illegal. Other cases which come to mind, 370 is being heard, thankfully now. The election funding case, these are matters which should be heard, which affect the rights, because the election funding case has a direct material on democracy. This is also part of part 3. So therefore, there has been the good and the bad, like always. But I think we can be proud of certain judgments. Well, not so happy with some of them. And that's my personal view. All I can do is end by quoting Charles Dickens. It was the best of times. It was the worst of times. It was the age of wisdom. It was the age of foolishness. It was the epoch of belief. It was the epoch of incredulity. It was the season of light. It was the season of darkness. It was the spring of hope. It was the winter of despair. But I'm always an optimist, and I'm sure the spring of hope is ahead of us. Thank you all very much.
Thank you so much, sir, for giving a very comprehensive view about last 10 years fundamental rights jurisprudence, discussing the good, bad, and the ugly of the Supreme Court developments. So we have few questions. We'll take a few very short questions because of positive time. So there is one question.
I think I'm overshot by 10-15 minutes. I'm sorry, but
no, not an issue, sir. So we have one query regarding your judgment in the independent legal thought case. So you've mentioned that it's one of a judgment which is very close to your heart as well. So, and you have also mentioned that right to privacy is going to be a very important right in the coming years. So in this background, how do you see the issue related to marital rape exception in the Indian Penal Code? Now that issue is pending before the Supreme Court following a split verdict in the Delhi High Court. So one viewer wanted to know your views on this.
In the judgment, we had specifically in an independent thought judgment, both Justice Lokur and I had very clearly mentioned that whatever we are saying should not be taken to be anything on marital rape. And I'll tell you the reason why we said so, because we knew that the matter was pending before the Delhi High Court, and we did not want, our observations to be used. But now, when I sit as a retired judge, I think my observations will be the same. And I think again, a woman has a right to say no. She has a right to say no to her husband also. Are we not equals? If a man and a woman are equal, just because you are husband and wife, the wife doesn't have a right to say no to have sex. And when she says no, it means no. I think there's nothing more than, it's a very simple argument. It's just that we have to outgrow our patriarchal and very archaic systems of thought. Otherwise, there's nothing. This is the most simple thing on earth.
Okay. Sir, another viewer wanted to know about your most favorite judgment.
No, you can't. One doesn't have favorite judgments. One doesn't have favorite judgments. One has some interesting cases which one has done, which may not even have decided any issue of law, but where you've changed the lives of a few. For me, sometimes those cases are much more important than cases where I've decided many, legal points which are, full of authorities and all. But for me, some of the important judgments would be ones where I've helped people more in the realm of social justice, public interest litigations, where society at large will benefit.
Yes, sir. So the last question we'll take. So you had mentioned in your lecture about Anuradha Basin's judgment, and also you had also criticized how the Supreme Court did not refrain from giving actual relief. So you mentioned that constitutional courts should actually give relief after holding that certain actions are unconstitutional. So how do you see the certain approaches taken by the Supreme Court in some of the recent cases? For example, the ED director case and cases like that, where even after holding that some things are illegal or unconstitutional, the court allows them to continue.
All I can say, if I was sitting on the bench, I would not allow them to. Sometimes, we have to be practical also. Let me be honest. Like sometimes, maybe an extension, you hold it to be illegal, but you can't have the post vacant even for a single day. And it will take time. But in the ED director's case, since you have referred to that case, this is not the first time it's been held illegal.
Right.
If the reiteration is the second or third time, and then the government should be ready with the name. And as Justice Gavai had rightly observed, you can't say that everybody else is incompetent and only this one person is competent to look after this. So therefore, I think the court did give us smaller extension this time than they had given earlier. But you see this, I agree with you to a certain extent that the courts, they should be very chary of giving or passing orders which run counter to their own arguments. But sometimes you have to be practical. You can't, I set aside if we set aside the appointment of a very high authority, unless there is somebody next in waiting who can be appointed immediately, yes. But if there will be going to be a time taken, you have to give that much time to the incumbent to continue, a reasonable time.
So the last question, a short question. So do you think that the Supreme Court should be doing more or should be more assertive in protecting rights? Or do you think that the Supreme Court is not doing enough?
No, I only feel that the Supreme Court is, I've said this many times, the Supreme Court is not only an adjudicator of disputes, it is also the protector of the human rights of the citizens. See, ours is a unique constitution where we have an Article 32, where if my fundamental rights are invaded, I have a fundamental right to go to the Supreme Court. Which other constitution has that provision? Now, does not that in itself show that the Supreme Court has been given the duty, a duty is cast on the Supreme Court to protect the fundamental rights of a citizen. You see, let me be very clear. I'm not saying that every time a fundamental right is violated, the Supreme Court must interfere, because then they will be doing no other work but this. But when there are important, wide-ranging matters where the invasion of fundamental rights affect large numbers of people, then the Supreme Court must enter. May not be in individual cases, but in.
Thank you so much, Justice Deepak Gupta, for sharing your views on with us. It was a very brilliant and erudite and enlightening session with giving a very comprehensive and balanced view of the Supreme Court judgments. Thank you so much.
Thank you, Manu. Thank you very much. Thank you.